This this is in continuation of our earlier discussion on the various topic which is very much relevant, particularly where the recent Supreme Court judgments are coming. We are trying to deliberate in one of the important is the coparcenary right of a female here, particularly the daughters here. Madam, may I request please keep yourself mute here. Please keep yourself mute here. The discussion will be mainly on the amendment which came into the Hindu Succession Act in Section 6. And we know that Section 6 has been replaced by the erstwhile provision. And the Section 6 has a very good implication here, particularly on the coparcenary right of the daughters. We will discuss the earlier provision also. We will also discuss some of the important Supreme Court judgment which has taken place in the earlier law. And subsequently, we will also discuss the famous case of the Vanita Sharma case here, because this case is very much relevant here, because it is a larger bench judgment by Justice Arun Misra. It is by Justice Arun Misra, wherein he has discussed thoroughly the important provisions of Section 6, particularly also the rights of the co-partner as a female, rights of the daughter. And we will also discuss some of the latest amendment or latest case law which has come following the Vanita Sharma case. So mainly discussion will be confined to the Vanita Sharma and mainly on the issue of the Section 6 of the Hindu Succession Act here. Our starting point will be that we will first discuss the Section 6, which was prior to the amendment. We will discuss the amendment part here, that what was the amendment law. And we will also discuss what was the object and region of the amendment here. We will come to the judgment of the Supreme Court in the case of Vanita Sharma, and we will see that how the argument has taken place from both the sides, and after that, what is the reasoning of the court to come to a conclusion here. For this purpose, we have the Hindu Succession Act, and we know that the Hindu Succession Act is the Act of 1956. And this act was for the purpose of codifying the Hindu law, and it was for the purpose of to amend and codify the law relating to interstate succession among the Hindus here. So particularly it was relating to dealing with the interstate succession among the Hindus, and we will come to the section which is the chapter 2, and we will come to the section 6, and let's see what was the section 6 prior to the amendment, and we will also see the section which was post the amendment, and we will see that what was the object and region, and after that we will come to the reasoning part and the conclusion part of the case judgment here. And we will discuss that why this judgment is important for our discussion. Section 6, what was the prior to this part here, prior to the amendment was that? It talks about, since the chapter 2 talks about the interstate succession, Section 5 talks about that act not to apply in the certain properties, and Section 6 talks about evolution of interest in coparcenary properties. So very much important. We are coming to Section 6, which was not an amended, before amendment here. Can you go to the unamended provision?
Yes, sir. You're on the unamended provision.
Unamended provision.
Yeah, this is unamended one. Can you see my screen?
No, it is the amended part here. The section here, it talks about devolution of interest in coparcenary properties. It's about the general rule of. It was the general rule. I'm not talking about the general rule. Just go top here. Down the line. Yes. It was earlier section 5 here. Let's see. Go to section 5. Yes. It talks about when a male Hindu dies after the commencement of this act, having at the time of his death an interest in Mitakshara Coparcenary property, his interest in the property shall devolve by survivorship upon the surviving members of the coparcenary and not in accordance with this act. Very much important was that section 6 talked about devolution of interest in a coparcenary property. So this section was about the coparcenary property only, and it was said that when a male Hindu dies after the commencement of this act, having at the time of his death an interest in Mitakshara coparcenary property, his interest in the property shall devolve by survivorship upon the surviving members of the coparcenary and not in accordance with this act. Subsequently, there's a proviso clause is that provided that if the deceased had left him surviving a female relative specified in class 1 of the schedule or a male relative specified in the classes who claims through such female relative the interest in the deceased in the Mitakshara coparcenary property shall devolve by testamentary.
Prakash,
yeah.
I do not think Section 5 has ever been there in the Hindu Succession Act. Is this the Hindu Succession Act which is being read? Because right from the beginning, devolution of interest in coparcenary property has been part of Section 6 of the Hindu Succession.
It is the same wording was there, Ajay.
It appears that what we are reading is something which has been adapted in Jammu and Kashmir with, I don't know, with some changes or not, but it may be verbatim, I don't know. But as a matter of fact, what we have in Hindu Succession Act right from beginning 1956 is the provision which is covering the devolution of the Mitakshara property, coparcenary right in a Mitakshara school. It's Section 6. It 5 seems to be, but it doesn't really make difference if it's verbatim.
No, I was trying to go through the Section 6. What was the earlier? What was the amended part here, and the object and region of the amendment here before we start our discussion on that part.
Okay.
So After that, there was a proviso clause. It said that provided that if the deceased had left him surviving a female relative specified in class 1 of the schedule, or a male relative specified in that class who claims through such female relative the interest of the deceased in the Mitaksara Coparcenary property shall devolve by a testamentary or intestate succession, as the case may be, under the Act and not by survivorship. So the first part was on the survivorship. The proviso clause was not on the survivorship, and there is explanation because all the three has its own importance here. For the purpose of this section, the interest of the Hindu Mitaksara co-partner shall be deemed to be the share in the property that would have been allotted to him if the partition of the property has taken place immediately before his death, irrespective of whether he was entitled to claim the partition or not. So this was the original part here. Can we go to the amended definition here? Amended law. Just go to the what was the amended law, please. Yes, sir. Naman, can you go to the amended law, please?
Yes, sir. Yes, sir. I'm opening it.
Yeah, please.
Yes, sir. Amended.
Yes. Now, and this is the subject matter of our discussion here. The substitute provision of Section 6 by the Amendment Act 2005 is structured hereunder. So, the devolution of interest in coparcenary property. Section 6, subsection 1. On and from the commencement of the Hindu Succession Amendment Act 2005, in a joint Hindu family governed by the Mitaksara law, the daughter of a co-partner shall, by birth become a co-partner in her own right in the same manner as the son. B. Have the same right in the co-partner property as she would have had it if she had been a son. C. Be subject to the same liability in respect of the said co-partner property as that of a son, and any reference to a Hindu Mitaksara co-partner shall be deemed to include a reference to a daughter of a co-partner, provided that nothing contained in subsection shall affect or invalidate the disposition or alienation, including any partition or testamentary disposition of property which has taken place before 20th day of December 2004. The date 20th day of 2004 is important. We will discuss that why it is important here. 2. Any property to which the female Hindus becomes entitled by virtue of subsection 1 shall be held by her with the incidents of co-partner ownership and shall be regarded, notwithstanding anything contained in this act or any other law for the time being enforced, a property capable of being disposed by her by a testamentary disposition. 3. Where a Hindu dies after the commencement of the Hindu Succession Amendment Act 2005, his interest in the property of the joint Hindu family governed by the Mitaksara law shall devolve by testamentary or intestate succession, as the case may be, under this act, and not by survivorship. And the co-passing property shall be deemed to have been divided as if the partition has taken place, and the daughter is allotted the same share as it is allotted to a son. The share of a predeceased son or a predeceased daughter, as they would have got had they been alive at the time of partition, shall be allotted to the surviving child of the predeceased son or such predeceased daughter. And third, C. The share of the predeceased child or predeceased son of or of a predeceased daughter, or as a child would have got, or had he or she been alive at the time of the partition, shall be allotted to the child of such predeceased child of the predeceased son or a predeceased daughter, as the case may be. Explanation. For the purpose of this subsection, the interest of the Hindu Mitaksha Coparcenary shall be deemed to be the share in the property that would have been allotted to him if the partition of the property had taken place immediately and before the date, irrespective of whether he was entitled to claim the partition or not. 4. After the commencement of this after the commencement of the Hindu Succession Amendment Act, no court.
Because if we stop for a while on
Yeah.
the provision that you just read, one second, he's removing it. One second. The provision you read right now was 3B, right?
Yeah.
3 says that the daughter is allotted. It's a deemed partition, right? Taking place.
Yes.
At the stage of death of the Coparcenary. And B says the share of predeceased son, predeceased daughter, and then it says child of predeceased son of a predeceased daughter. What is the purpose of this? I mean, see, because no similar provision was there in existing section 6. So when they are bringing in this provision here, the first part is clear that the daughter is allotted to the same share as is allotted to the son is very clear, right? Because the daughter has become a coparcenary now, along with the son by way of the amendment. So what could be the purpose of B? What does it and why it is? What does it seek to achieve? The share of predeceased son or a predeceased daughter, as they would have got had they been alive at the time of partition, shall be allotted to the surviving child of such predeceased. And then C also, predeceased son, predeceased son, predeceased. So A is direct consequence of the fact that the daughter has been recognized as a coparcenary. What could be the region of B and C brought in there?
In fact, it goes further, Rajay. It goes further. It says that not only the daughter, because not only the daughter, it says the daughter is allotted at the time, the daughter is allotted the same share as is allotted to his son. Okay. When we will connect it with the subsection 1, we will find that the right of the daughter will be arising from the birth itself here. So, she will be allotted the same share here as of the son here. She will be that part here. It is talking about the partition here. Just partition.
No, correct. So A explains that the daughter will get same as the son.
Yes.
What could be the justification of bringing in B and C there?
Yes, B and C further extend the benefit to a daughter. It says that the share of the predeceased son or a predeceased daughter of the predeceased daughter that would have got had they been alive at the time of partition. Suppose that the daughter is no more at the time of partition. The daughter has already died. The daughter is no more. Then the son of the predeceased daughter or a predeceased daughter, then the share of the predeceased son or a predeceased daughter, as they would have got had they been alive at the time of partition, shall be allotted to the surviving child of the predeceased son or the predeceased daughter. So it is not only talking about the daughter which has been and which will be allotted the same right to a son. It says that
A says that the daughter will get it as the son will get it, right?
Yes. Yeah.
B says if the daughter has predeceased the coparcenary who is dying now, then son or daughter of that daughter will get it.
Yes.
Right.
Yeah.
He is saying that if the son or daughter of that daughter, which has been mentioned at A, is also predeceased, then his son or daughter will get it. Right?
Yes. Yeah.
And then it stops. Why does it stop there? Why doesn't it go beyond, even beyond? Assuming there can be a case where the son or daughter of the predeceased son of the. I mean, there can be even next stage also in a given case. Why doesn't it cover it? Why does it stop here at C?
We will come to the discussion here. There is a specific
All right.
discussion. Yeah,
Because that raises a very legitimate thing that it stops at 2 stages and doesn't go beyond.
In fact,
Yes.
when we will be discussing the co-parcenary here, okay, even without the amendment here, okay, it was up to from the grandfather, father, son, and grandson. So it was the up to the 3 level it was there here. We will see that there is a discussion of this point here on this issue in certain para here. So our discussion is on the issue that the amendment which has been brought here in the 2005, how to read this amendment, whether this amendment will be a prospective, whether this amendment will be retrospective, whether this amendment will be retroactive also, because the court has discussed this part in detail here. Before going to the judgment part here, I would like to discuss and request Ajay so that he can go into the intricacies of both the provisions. One was the pre-amendment and what was the amendment part here. And if something is there, we will support here. Ajay, your view?
Hello? Sorry?
Ajay, yes.
Yes. You're saying something. I missed that part.
Before we go to the discussion on the judgment part here, okay, can we explain the provisions of both the provision, unamended provision and subsequently amended provisions?
Okay. All right. See, it's not only the unamended provision of Succession Act which is relevant or which should be. I think we can go a little prior to that to see how the devolution right or inheritance right of a daughter or a female in Hindu law has been there even before the Succession Act of 1956 came. Before.
Naman, you can remove this part here, the statutory part here. We can start discussion. Now the discussion will start here. Yes, please.
Before 1956 Act, we had you see, right from beginning, if we see the evolution of Hindu law, then we all know that there had been two schools, dominantly two schools of customary law that we had. One was Mitakshara and the other was Dayabhaga. Now, Dayabhaga is also called the Bengal School of Law because it was governing mostly the Bengal area in the beginning, whereas Mitakshara was covering many other parts. It had Binaras segment, it has Mithila segment, it had Maharashtra segment, and it was also applicable in South India. So most of the part was actually covering the Mitakshara law. Now, one of the major difference between Dayabhaga and Mitakshara as far as female right is concerned is that Dayabhaga did not have a concept of a separate property or a joint property. It always had a concept of a property, right? And the daughter were never. Dayabhaga was always considered to be more evolved and modern concept compared to Mitakshara, which was considered to be orthodox and conservative concept. Now, therefore, Mitakshara always denied the thing which Mitakshara made two separate categories, or rather three separate categories of properties. One was ancestral property, which came from the father and forefather. Second was separate property, which came from people other than father or forefather. It could have been uncle, it could have been brother, it could have been mother. So that was separate property. And third was self-acquired property, which the person acquired by his own effort. So Mitakshara always said that in as far as the ancestral property is concerned. Now there is also one thing that we should understand before we pick this up. That this what is the difference between a coparcenary property and a joint Hindu family property, HUF property that you call. Now, coparcenary property is the property which is coming in the hand of the holder through his father or grandfather or great grandfather. Whereas any other property, which assuming there is a joint Hindu family which is living where there are more than one descendants and several collaterals, brothers and sisters, and they are living together. So when all of them are bringing in property and putting it in the common hodgepodge, that is becoming the joint Hindu property. So the difference between joint Hindu property and coparcenary property is that coparcenary is something which has come to you as an ancestral property, as a gift, whereas every other property that the members of the joint Hindu family property earn and put to the common hodgepodge, right, or common stock, it becomes a joint Hindu family property. Now, as far as joint Hindu family property is concerned, when somebody died intestate, then the devolution took place according to the law of succession. Correct. Now, who was entitled to succeed? Who was not entitled to succeed before Hindu law or before Hindu Succession Act or before even the law which was prevalent during the British period? That's a different subject to this, right? We'll see that. But then, as far as the ancestral property was concerned, there was no concept of intestate succession or testamentary succession or disposition by will. It always happened through survivorship. And therefore, the concept of coparcener is something which is attached with the concept of ancestral property and survivorship. Apart from that, when the joint Hindu family property comes and plays its role, then it's not the question of survivorship. Then it's the question of intestate succession and the heirs who are in the different categories, they will succeed accordingly. So that is as far as as a broad concept of joint Hindu family property and coparcenary property is there. To put it succinctly, coparcenary property is a property held in the hand of a person who receives it through his father. So the property in my hand, which I have received through my father, becomes coparcenary as far as I am concerned and my son is concerned, my male descendant is concerned. If I do not have a son, that property remains in my hand alone, and it has not yet acquired the character of a coparcenary property, because I am you may say it is a coparcenary property, but I am the sole surviving coparcener at this moment. The moment a male descendant comes to me, my son comes to me, that property, I and my son together constitute a coparcenary. And that property which is in my hand, which I have received through my ancestor, that becomes a coparcenary property. Now, the extent to which the coparcenary property concept applies is, if my son has a son later on, and his son has a son later, then 1 + 3 is 4 degrees of the lineal male descendants comprise coparcenary. And qua those 4 descendants, lineal descendants, the property that I'm holding in my hand, which I have acquired from my forefathers, is the coparcenary property, in which they all have equal share by virtue of birth. And that is why it's called unobstructed heritage, because there is nothing which is obstructing them. Right? The moment they took birth, they are entitled to have a share in that property, and their entitlement is equal. Now, that is as far as the coparcenary property is concerned. Now, there are different circumstances. Can there be, if there are 5 lineal descendants, can they all be coparceners? Or can the 5th descendant, suppose A, B, C, D, E is there, then can E be said to be a coparcener? Or what is the privilege that the coparceners have, apart from the fact that they have equal share in the who can seek partition of that coparcenary property? Nobody else can. So E, who is 5th in the lineal male descendant, is not a coparcener, and he cannot seek partition of the coparcenary property. But the moment A dies and the property in A's hand comes to B, then B becomes the coparcener with regard to whom E also becomes a coparcener now, because E then lifts itself up to the 4th degree. Then B, C, D, E, they become coparcenary within the 4 degrees. And then E gets the right of actually equal share and taking partition with regard to only with regard to the coparcenary property. He doesn't get a share in the equal share in the joint Hindu property. Nor does he get a right to seek partition of the joint Hindu property. He seeks the right to he gets the right to seek partition. Yes.
I have one point here. Just we discussed that A, B, C, D up to D it was there, so there was no
Coparcenary.
Yeah, coparcener was there. E, although E has taken the birth, but E cannot be treated as a coparcener because the A is still surviving.
Yes.
Therefore, can we say, as far as the E is concerned, it is not an obstructed, it is an obstructed heritage here, because he has to wait for
that.
Yeah,
we can say that. Yes.
Yeah, because he cannot be a co-partner till the death of the Mr. A.
A. Yes. Yes.
So the concept of unobstructed heritage here, for the purpose of co-partnership here, can we say that in some cases it will be treated as a obstructed heritage, and the unobstructed heritage is not an absolute here?
No. With regard to E, it is an obstructed heritage, and the obstruction is the happening of an event which is called death of A.
Yes.
So that with regard to E, the coparcenary property in the hand of A is an obstructed heritage.
Yes.
Yes. Now that's one part of it. Then second, if we see what happens, there is another very interesting aspect of the coparcenary property and the manner in which devolution takes place, and somebody can get share and somebody may not get share. For that, let's assume another instance. A has a son B. B has a son C. C has 2 sons, D and D1. Anybody who is not able to visualize can draw on page to understand it well, because what I'll be speaking will be based on this chart. So A has a son who B has a son C. C has 2 sons, D and D1, and D has a son E.
So D1 has one son E.
D1 has one son E. Now there is a coparcenary at this moment as far as the lineal descendant of D and D1 is concerned. Correct. E is out. E is removed coparcener at this stage. He is not within the degree 4 degree of coparcenary.
Yes.
Yes. Now D and D1. Now there are 5 coparceners, where D and D1 are the collateral coparceners. Okay. Okay. So the share of A would be 1/4, of B would be 1/4, of C would be 1/4, and of D and D1 together would be 1/4, alternatively 1/8 each. Right. Now let's take an instance that B dies. B predeceases A.
Okay.
Naman.
Yeah, please tell. I'm just
Naman.
Yes, sir.
Listen to it very carefully, because the task which I have assigned to you people, it should take into account all these things also. Huh? Now, now
I have a
say
few
B
questions
dies.
also, sir.
No, we'll come to the question later on.
Okay.
Now B dies first in time. All right. Now, in case B dies, can we say that E has become a co-partner?
I don't think so,
Why?
because it is starting from A, B, C. So the point is that still it is starting with A. Only point when it will come down here, only when A dies here. But since
Okay.
B has died before A here, so the co-parsing right still lies with A.
Let's see. Fine. Yeah, fine. Okay. Now let's see. Next, C dies. Even then, E has not become a co-partner.
Yes.
Because he is still removed.
Yeah.
Subsequently, D1 also dies.
Yes.
Now, even then, E has not become a co-partner.
Yes.
Right?
Yeah.
Now what happens? Now what happens is that in that coparcenary, only A and D are copartners.
Yes.
Since B is removed by 3 degrees prior to him, it's E. So E is out at the
Can
moment.
you repeat? Yes. But if the B dies here?
Sorry?
Hello?
Now the coparcenary is constituted by A and D only. There is a coparcenary yet, but there are only 2
There is some
copartners
internet
in this
problem from
coparcenary.
Ajay's side.
Hello, can you hear me? Am I audible? Can you hear me? Hello, am I audible?
Yes, sir, you're audible. I think Prakash sir is
No,
joining.
Prakash signal is gone. So anyways, because his screen is frozen. Hello? Okay, so should I carry on? Should I continue?
Yes, I feel that there is some disturbance here. Yeah,
No,
please.
am I audible? Should I continue? Okay, okay. Now in this particular illustration where B, C, and D have died, and E still remains a removed copartner. The coparcenary is now constituted by A and D alone. Okay. Now at this stage, A dies. The consequence of it is that E is already ousted. The moment there is a gap of 3 predecessors, father, grandfather, and great-grandfather, if they are gone, then E cannot come into coparcenary. So upon A's death, it's only D who remains as a copartner, and he is called sole surviving copartner. Okay. And the entire coparcenary property will be vested in him. Till the time he gets his son, who may be F, then D and F will form a coparcenary with regard to that particular coparcenary property. And interestingly, E is ousted. Okay, so these are some interesting aspects of coparcenary property and how they are devolved. 2-3 concepts are there. One is that the coparcenary is a creature of law. It cannot be created by the act of parties. But then by adoption, it can be. So somebody can adopt a third person and he can become a copartner later on. That's what Supreme Court has said. And then one of the law of coparcenary was that no female can be a copartner, which changed, of course, after 2005 Amendment Act, which we shall be dealing with later on. Now, Now, as far as inheritance of female is concerned, now what happened in Coparcenary property right from beginning, that female did not get. A female, including daughter and widow, they got some property. The only property that they were entitled to have was Sridhan that they had, or in joint Hindu family property, they got property by way of inheritance, but that was only a limited entitlement. That's not an absolute entitlement. And initially the right to inheritance was confined to only 5 persons. It was not confined to all those people who are now. Now we have probably 13 or 14 people in class 1 who are entitled to inherit, or probably 9 or 10 female members in class 1 who are entitled to inherit. Initially, there were 5. In 1929 came Hindu Law of Inheritance Amendment Act. So 5 people who were originally the heirs who could have got inheritance right were widow, daughter, mother, father's mother, and father's mother. If we open the first schedule of Hindu Succession Act, we can find that.
Naman, can you go to the first schedule? Schedule
Yes.
then 1 to class 1. Just find out
Class
the
1
class.
heirs.
Yes,
Class
I'll
1
do.
heirs. So if we see there is daughter, then widow.
Son, daughter, with son is there, first son.
No, so forget son. We were talking about the female heirs. So one is daughter, which was there right from beginning, before any intervention, even during British India. The heirs who were entitled were daughter, 1, widow. No, so widow, yes, 2. So widow is there. Widow of
Yes, widow is there in the.
widow, daughter, widow. Then mother is there. Then
Yes.
father's mother, who doesn't seem to be there now. I think she has gone to the class 2. Father's mother. See class 2 Roman 5.
Father's mother, yes.
So she father's mother and father's mother. Father's mother is now not there at all, it seems.
No, only father's and father's mother.
So originally the five females who were entitled to inheritance right were widow, daughter, mother, father's mother, and father's mother. In 1929 came Hindu Law of Inheritance Amendment Act, whereby three persons were added, and they are son's daughter. Now, son's daughter we can find in class 1 even now.
Daughter of a predeceased son.
No, not predeceased. It says simply son's daughter. So it might go to class 2 or wherever. Three who were added were son's daughter, then daughter's daughter, and then sister. So totally it made 8 people who were there as female heirs who were entitled to inheritance right. Thereafter, the major statutory change which happened was the Hindu Women Right to Property Act in 1937, which happened after the Government of India Act came in 1935. Now, after that, with regard to widows' right to property, some changes were brought by the legislature, and that is by virtue of 1937 Hindu Women Right to Property Act. Do we have that, Naman? If you do not have
Yes,
that,
I'm just-
Hindu Women's Right to Property Act.
I'm just opening it, sir.
Oh, okay. Now, this was the act by virtue of which the widows were given in case any Hindu having interest in the Mitakshara Coparcenary property died. Let's open the provision. Let's see the provision. The title is Devolution of Property.
Yes, I'm on it.
Okay. Can you put it on the screen, please?
Yes, sir.
Now it says
It is not visible.
devolution of property.
Naman, it is not visible.
Yes, sir. Some error. Wait.
Yes, it is there.
Okay.
Is it there? Sir?
It says, it's okay. Though it says Pakistan, but it's the same one which is in India also. You can bring it down. Just scroll down to section 3, please. Scroll down further. Scroll down. Yes. Go up. Okay. It says devolution of property. Now, it says when a Hindu governed by the Dabhaga school of Hindu law dies intestate, leaving any property. Mark the word any property when it comes to Dabhaga school. Okay. Because Dabhaga school never had this system of ancestral property or Coparcenary property or separate property. With regard to every property, the daughters in Dabhaga school, right from beginning, right from day one, had the right as the son had. So there was no discrimination as far as Dabhaga school was concerned, right from beginning, the Bengal school. So it says, when a Hindu governed by Dabhaga school of Hindu law dies intestate, leaving any property, and when a Hindu governed by any other school of Hindu law or by customary law, so any other school of law will include Mitakshara, okay, dies intestate, leaving separate property. So what the woman is getting here, widow, in case she is governed by the Dabhaga school, it can be any property which can include the ancestral property or Coparcenary property. But in case of Mitakshara, the thing that is she is getting by virtue of subsection 1 is only the separate property. It says living in a separate property. His widow, or if there is more than one widow, all his widows together shall subject to the provisions of subsection 3. Subsection 3 says that they will have the limited interest, the limited right. They cannot dispose it of, they cannot sell it, right? So subject to subsection, they will have right of maintenance, the right of utilizing the benefit of that property, right? If the property is rented demise, then the rent of that can be had by them, etc. So it's subject to subsection 3, be entitled in respect of property in respect of which he dies intestate to the same share as his son. So what it says is that in case it is Dabhaga, then any property which the son is having a share in, out of that property, the widow will get as much as it, right? So that's equal. So 50-50 between him and son, it will be divided. To separate son, what happens if there is no son? Go down. There are provision. No, it doesn't say anything. No son. It says something else. It covers, apart from the widow of the person who has died in subsection 1. Now proviso covers the widow of son of that person who has died. So son of predeceased. So this is widow in the second line of descendants, provided the widow of a predeceased son shall inherit it in like manner as a son if there is no son surviving of such predeceased son, and shall inherit in like manner as a son's son if there is a surviving sons of such predeceased son. Now, without going into the rigmarole of these words, let's understand this. And I think that is the answer of that provision also, Prakash, which I had interjected in the beginning.
Mhm.
What they are intending to do is that since Coparcenary intends to say 4 degrees of linear descendants, therefore everywhere where such protection is coming, here by virtue of subsection 3, the protection to the widow is coming, which is the protection particularly and majorly with regard to the maintenance of the property. Once that widow died, then that property would go back to the other lineal descendant or other entitled person within that coparcenary to whom it originally belonged, right? And that person is called reversioner. So that reversioner who is waiting for the widow to die will get it back in that lineage of the family itself. It will not be given to the legal heirs of the widow. Property is there to the widow under 1937 Act only for the purpose of maintenance of the widow. The moment widow is dead, the property reverts back to the lineage of the husband. It revests. And that is why subsection 3 says that any interest devolving on a Hindu widow under the provisions of this section shall be the limited interest known as Hindu woman's state, provided, however, that she can claim partition, but she can't dispose it of. That's subsection 3.
So
Okay.
her right is to partition, not the right of the disposal.
Her right is of maintenance. Her right is to seek partition. She can use the property in a like manner in which her husband could have used. She has complete entitlement with regard to that property. She can enjoy the procurement of that property, but only till her lifetime. So majorly, it was in the form of a maintenance kind of a arrangement which was done. Now, so the major thing which is to be looked here is that it was a limited ownership. She was not an absolute owner. What happened thereafter? Thereafter, independence happened and came the Constitution in 1950. Where came Article 14 and 15? The 15th clearly says that the state will not make any law or even the pre-existing law which are in violation of Section 13. Any law made in violation of fundamental rights, they'll be accordingly taken care of, right? So 15 clearly says that no law can be made which is discriminatory on the ground of caste, creed, sex, etc., right? Now that may not have played that much of a role, but one thing happened thereafter is that in the Hindu Succession Act, please go to section 14, Naman. What 14 did, apart from 6, there are 2 provisions that we will see in Hindu Succession Act. Section 6, which you read,
So section 14 of
unamended
Hindu Succession Act.
Section 6. Hindu Succession Act 1956, unamended.
Section 14.
Section 6 first. Section 6 talks about devolution.
Unamended or amended, sir?
Unamended, sir. Now, there are 3-4 provisions which are very relevant here, which we must see before we proceed further in order to understand well what Justice Arun Mishra is saying in Vinita Sharma, or how the law has evolved until Vinita Sharma, or maybe even later. So let's see that. Section 6.
Naman, please share, Naman.
Yes, sir. There's a Wi-Fi issue. It's loading. Just
No, it's okay. We'll wait. Now, I'll go on in the meanwhile. What sections you can bring it on screen, but what section 6 basically did is that it provided for devolution of interest in coparcenary property of a Mitakshara Hindu. Now it has brought back the concept of coparcenary property and how the property will be devolved if any coparcener dies. It says
You are reading-
it will devolve. Sorry?
You were reading section 6.
6. Pre-amendment.
Yes.
It says it will devolve by survivorship amongst all the surviving members of a coparcener. What does it mean? Members of coparceners have to be all the male members until 4 descendants, correct? 4 degree of male descendants. So section 6 clearly says that as long as there is a Mitakshara property, and if any coparcener has any interest in that Mitakshara property, here you'll have to bring 5. Section 5 in this one. So, as long as there is a Mitakshara property and any coparcener has any interest in that Mitakshara property, if that coparcener dies, then devolution will take place as per the survivorship and it will be devolved only upon those male members who are members of the coparcenary. It will not go outside the coparcenary. That is section 6, recognizing the existing position as of now. So the Article 15 has not done much at this stage to actually remove this discrimination among a son and daughter of in a coparcenary property. Then, apart from this, section 6 also says one thing. The proviso says that all the female beneficiaries who are there listed in
Class
schedule,
1.
in class 1 schedule, the rule of survivorship will not, if there is any of them there, then the rule of survivorship will not apply. Then what will apply? Intestate succession rule will apply. That's very important. Even if it's not a complete thing which has been done in favor of any daughter, but it's not only daughter, any of the 9 beneficiary who are falling in class 1 of the schedule, because earlier it was 5, then it was 3 added, 8, and then there is one more added here by virtue of this. In this class, there is one more person added, one more lady added. So there were total 9 beneficiaries. Proviso says that if at the time any coparcener dies, and if there is any of the beneficiary in this class 1 who is surviving, then a devolution will not take place through survivorship, but through intestate succession. That means their right of maintenance till the lifetime has been recognized. But then whether absoluteness has been there, whether they can hold the property if intestate partition takes place, whether they can hold the property as an absolute owner thereof or not, that's another question. We'll look into the answer of that. But then it at least recognizes the fact that any of the 9 claimants, if any of them is surviving, then the property will not devolve automatically to the surviving male coparcener, but it will go to the class 1 heirs according to the intestate succession rules, which has been given under the Hindu succession. So that's one very major change.
On this issue, that in case that there is a female which is surviving in the class 1 female is surviving, any of the, like you have mentioned that there are 9 females here. If any,
we can see that the mother is there, widow is there.
Yes,
all those people.
Yes.
Daughter is there.
Any of the females surviving is that the property shall devolved by testamentary or intestate succession, not by the survivorship. So
let's read this provision which is there on the screen. Provided that if the deceased has left him surviving a female relative specified in class 1 of the schedule, or a male relative specified in the class who claims through such female relative. So female relatives are 8. This male relative is one more who is claiming through a female relative. So there are total 9 beneficiaries. The
Yeah.
interest of the deceased in Mitapshara Coparcenary property shall devolve by testamentary or intestate succession, as the case may be under this act, and not by survivorship. Yes. So your question is?
That in this case here, if it is then, if there's a lady is there or the female is there, so what will be the right of the female, whether he will get the partition right, or whether she will get the maintenance right from such property, or whether she can also dispose the property also, because till the time there is no partition also. So I feel that there will be no disposal of the property. Disposal right is not there with the lady. Only the right.
So yes. The answer will come in the we'll have to see the changing complexion like this. Until 1937 Act, which carried unto 1956 coming of this Hindu Succession Act, they were having a limited ownership right. They could have sought partition of the property, but they could not have disposed it off, right? Now, as we read Section 6 now, it is very clear from reading of the proviso that the property, Coparcenary property, is not going to the male members alone. In case if there are any female of class 1 surviving, and instead that is going by survivor of the intestate succession or by the testamentary succession. What will be the nature of the property when it's given to them by virtue of the testamentary or intestate succession? Once the property is devolved to them, what is the nature of the title that they will be holding? Will it be limited like it was previously, or will it be absolute? And once it is absolute, will they be able to do it, deal with the property in the manner in which they want? The answer will come very, very soon. But before that, let's see explanation 1 and explanation 2. Explanation 1 basically says what is the interest of a coparcener. The interest of a coparcener which is being devolved under Section 6 here. What does that interest mean? That interest is the share of that particular coparcener, as if there was a partition which had taken place immediately prior to his death, and he had a particular share in the Coparcenary property. That share will be devolved upon the legatee, upon the legal heirs. So that is the interest which is being talked about, his share immediately before the death. Then explanation 2 says that if any of the beneficiary in class 1 had separated herself from the joint Hindu family, then she would not be entitled to the benefit of the proviso. So the proviso, which is coming to the help of the beneficiary in class 1, if any one of them has separated herself prior to the death of the coparcener, then she will not get the benefit. That's what explanation says. Okay, so that's not relevant as far as the transformation and maturing of the right of a female into her absolute ownership is concerned. I think what is relevant is one very vital change has been brought by virtue of the proviso of Section 6 subsection 1. Now let's go ahead. Let's go to Section 14, which might be Section 13 here, Naman. That says property of no, go up.
Up, okay.
No, go to 14.1 for a moment.
14.
The actual provision is Section 14, yes.
So 14 talks about property of a female Hindu in her absolute property.
Where is no. So in this case, it will be 12 maybe. Go to 12.
No, here it will be yes.
Go to 12. Hang on. The property of a female Hindu to be her absolute property. This is actually Section 14, not 12. Right? Female Hindu, whether acquired before or after the commencement of this act. See, if she is possessing any property by virtue of the maybe 1937 Act, or by virtue of any other instrument or device, she has been gifted, or she has been willed, or whatever. Any property that she is holding prior to the commencement of this act, or after the commencement of this act. Now, when we say after the commencement of this act, we definitely will include the property which are being held by her by virtue of the proviso of section 6 of section 1, which is coming to them by virtue of either intestate or testamentary device. Okay. So it says any property possessed by a female Hindu, whether acquired before or after the commencement of this act, shall be held by her as her full owner. So the limited ownership of 1937 Act matures into full ownership in 1956, in as far as a female Hindu is concerned, for any property that she is possessed of and she is holding. Go below, please. Now, explanation 1 defines property. See the bits of this definition. In the subsection, property includes both movable and immovable property acquired by a female Hindu by inheritance or device. So it may be inheritance or device, or at a partition. So any property that she gets in partition. Suppose 1937 Act, she has a right to partition. She got a partition and she's living on that. And by the time she's living on that, and she's not dead, and the property is not reverted back to the family member of the husband, and comes this act, then the date on which 1956 Act came into being, her limited title under section 3 of 1937 Act matured into her absolute title under section 14 of the Act, and then she is then any reversioner. There are many cases in which reversioner files suit for the purpose of, once this widow died, reversioner files suit for purpose of taking possession back. It cannot go back to them, because then once the right matures under section 14, then it becomes her absolute property, and then it is the LR of that woman, that widow, who will be rightfully entitled to claim those particular property. Why? Because it has become her absolute property. Now, so therefore it says
so you want to say that there is a big departure from the 1937 Act, where the
it is indeed.
Wherein the right to the female was a very limited right. Only to the widow was very limited here, only for the maintenance and only to seek the partition, not for the ownership here, or not for the co-parsing right here. And here it talks about that it is the not a limited ownership, but it is a full ownership right which has come through the section 14 of this act here, under the Mitakshara law here. Whether this will apply to the Devbhaga also?
Devbhaga never this limitation. Devbhaga was open to women all from the beginning.
Okay.
So it will apply to Devbhaga also. It will apply to any of them. After 1956 Act, it's applying to both. Because there is no segmentation of as Devbhaga, unlike in 1937 Act, there was a differentiation made in Devbhaga and Mitakshara school. They haven't done it in 1956 Act. So then the bits of property is given. They include movable, or any property acquired through inheritance, device, partition, in lieu of maintenance or arrear of maintenance, by gift from any person, whether a relative or not, before or after her marriage, or by her own skill exertion, or by purchase. So, everything included. Now, subsection 2. Nothing contained in 1 shall apply to any property acquired by way of gift. Now, it's a limited. It says that where any such instrument which has given the entitlement to the woman with a reservation or with a qualification that it has to come back. Suppose somebody makes a will in her favor, that after your death it has to come back to them. Or if somebody, if there is a court's order or decree whereby such a condition has been imposed, that this is only in lieu of your maintenance. After the maintenance, the property will go back to the reversioner or go back to the family of somebody else. Then subsection 1 of 14 giving absolute ownership thing will not be applicable to that. Right? So these are two very important provisions which came in 19 56 in Hindu Succession Act. Now thereafter, there is one more provision that we should have a look at, which is section 30. Section 30, which may be section 28 here.
Which talks about testamentary succession.
Testamentary succession. It says that a Coparcenary property, the share of any Coparcener can by testamentary instrument dispose of his share. Does it say so? Can you open that provision, please? Section 30.
This one, sir?
Section 30 of section
30.
30. It might be 28 here. Yes.
Okay. 28, it's repealed. 27?
Shall I read it?
I'll read 30. Huh? I have it.
Yeah.
I'll read it.
Okay.
Subsection 1. Any Hindu may dispose of by will or other testamentary disposition any property. As of now, there is no reference of Coparcenary. Any property which is capable of being so disposed of by him. Now, the property which is capable of being disposed of, if we see the Indian Succession Act of 2025, it will be very clear that those properties are the properties which are separate property or self-acquired property. Ancestral property cannot be built. Right? So they say any property any Hindu may dispose of by will or other testamentary disposition any property which is capable of being so disposed of by him in accordance with the provisions of the Indian Succession Act. That means the property which you can dispose of in accordance with the Indian Succession Act or any other law for the time being in force applicable to it. So any Hindu can do that. They dispose of any property which he is capable of disposing of by virtue of will or any other instrument. Now, explanation is very important. What the explanation is doing is that explanation is bringing in his interest in the Coparcenary property also within the scope of disposition. The interest of a male Hindu in a Mitakshara Coparcenary property, or we leave the remaining part, Mitakshara property, notwithstanding anything contained in this act or in any other law for the time being enforced, be deemed to be a property capable of being disposed of by him or by her within. Now, her has come after the amendment of 2005 within the meaning of this subsection. For the removal of doubt, it is hereby declared that nothing contained in subsection 1 shall affect the right of a maintenance of any year. Now, please see this subsection 2 again. Here again, at the time of disposition, when we saw section 6 proviso, it said not survivorship but intestate succession. Why? Because there is somebody who is to be maintained in class 1. Here again, it's saying that even if you're alive and you want to dispose of your share in the Coparcenary property, your interest in the Coparcenary property, you should not do that as long as there is a beneficiary in class 1 alive. It says, for the removal of doubt, it is hereby declared that nothing contained in subsection 1 shall affect the right of maintenance of any heir specified in schedule by reason only of the fact that under a will or other testamentary disposition made by the deceased, the heir had been deprived of a share in the property to which he or she would have been entitled under this act if the deceased had died intestate. Correct. So if she was entitled under 6.1 proviso, then that entitlement cannot be disrobed or taken away by virtue of a disposition that the Coparcenary is trying to make under section 30. Correct. Now thereafter, 31 is the one which has repealed 2 Act, Hindu Law Inheritance Amendment Act of 1929, whereby 3 more beneficiaries were added to class 1, and then Hindu Women Right to Property Act 1937. These 2 acts have been repealed. Now this is what the Hindu Succession Act pre-amendment was, and if we recall section 6, which is now amended, is pertaining to the right of a copartner, devolution of interest of copartner in Mitakshara Coparcenary property by virtue of survivorship only amongst the male descendant copartners. No daughter. So therefore the change. Now let's see the change which happened in 2005.
Go to section 6.
Section 6 of 2005. Now, what are the changes? First change is that the daughter shall be a co-partner. So section 15, article 15 plays full role here, full disclosure here or full effect here, whereby this discrimination as far as coparcenary property was concerned by virtue of a statutory provision has been taken away. So in clause 1, she has become a copartner, as good as a son. And in clause 2, she will have same right as that of a son. And C, she will have same liability as that of a son. Then it also says that any reference to Hindu Mitakshara copartner shall be deemed to include a reference to daughter of a copartner. Then provision is important. It says that any disposition or alienation, remember section 30 that we read of the existing section 30 of Hindu Succession Act, where under copartner has a right to dispose of or alienate. It says, provided that nothing contained in this succession shall. So, section 6 amended will not affect anything which has happened prior to 20th of December 2004, which has happened under section 30.
So disposition has been saved here.
Saved here, yes. But I've come across a judgment. I need to yet still examine it by J.B. Pardiwala last month, coming from Odisha High Court, in which a prior disposition has also been ignored. In that case, what happened that after there was a consent decree which arrived at, after from the date 10 years after that consent decree, based on which the preliminary decree of partition was passed and final decree was still awaited, came this act. The daughter goes to the court, challenges that consent decree, saying that it should not have been arrived at, and I'm entitled to share as a copartner, so I should be given the share. Now, based on that consent decree, there was already a disposition made under section 30 by the concerned copartner. He disposed of his interest to the third party. That, despite that, the court has actually gone back and given the right. So I'll have to examine that judgment. That's J.B. Pardiwala's some Sahu, I don't know.
I think that it was some Sahu case was there. Chahulata was the lady who has come to the court for this.
Prasanta Sahu versus Chahulata.
Yes, Chahulata was there, and I feel that in that case also he has referred this judgment itself, Ajay.
No, it's okay. No, my only point. See what I'm saying is that what has happened in Vinita Sharma, though it's a huge judgment, but if we it's more of a recitation of this history that we are reading now, that we are discussing now. So if most part of the judgment is actually dealing with these developments and etc. The relevant part is that whether a daughter can take the benefit of it only after the cutoff date, or even with respect to a prior development. That's a limited question with regard to which the differences were there between the two judgments, Prakash Tulvati and other judgment. Now that part has been dealt in a very small scale. Similarly, when this judgment of Pardiwala we talk about, there also a lot of discussion has been there, but then the aspect has been dealt on a limited area. So we'll see that, not Pardiwala today, because Pardiwala I still have to examine that part as to how that has previous disposition has been ignored. We'll see that. We'll confine this time to this Sharma case. Now let's see this. Subsection 3.
Yeah.
When a Hindu dies after commencement of Hindu Succession Act, his interest in property of a joint Hindu family governed by Mithakshara law shall devolve by testamentary intestate succession, as the case may be, and not by survivorship. So that's a clear change in law from the existing Section 6, where it happened through survivorship. Now they are clearly saying that after 2005, it will not be survivorship, but by intestate or testamentary succession, as the case may be. Correct? And
yes, I feel that there's a departure, yes, in Section 3, Subsection 3. It talks about
that's what I'm saying.
where a Hindu dies after the commencement of Hindu Succession Act 2005, his interest in the property of the joint Hindu family. Okay. It does not talk about the coparcenary, whether it will be covered by the coparcenary property. Let's see this part here. He say that his interest in the property of joint Hindu family governed by the Mithakshara law. Okay, it will cover the shall devolve by a testamentary or intestate succession, as the case may be, under this act, not by the survivorship, and the coparcenary property shall be deemed to have been divided. If the
that clears all the doubt.
Yeah, if the
On the
partition,
coparcenary property.
so it is a deemed partition they are talking about.
So what is the and the daughter will get as much of a share as the son. Now what is this is very important provision. I'll tell you why. So kind of interplay which is happening here is, let's understand that for a moment. If we go to existing Section 6, there what happened the moment a Mithakshara died, the moment a Coparcenary died, by virtue of survivorship, immediately the succession opened, and immediately and simultaneously with the moment the death happened, the partition took place, right? In the sense, the notional partition took place. In the sense that the notional apportionment of share took place. Nothing else was required. By statutory provision and by the deeming fiction of law that it will happen by survivorship amongst the surviving coparceners. As soon as the death took place, the share of that coparcener automatically got adjusted amongst the share of the surviving coparcener. Right? That was the existing Section 6. I hope I'm making myself clear. Is it clear?
Yeah, please go ahead, Ajay.
No, what I'm saying is the change which we need to understand here is that in the previous in the existing Section 6, since the devolution took place by survivorship, the moment coparcener died, his share was automatically adjusted amongst the share of remaining coparcener who survived. Nothing else was required to be done. There was an automatically allocation of the shares, and the shares were accordingly adjusted amongst the remaining co-partners, male surviving partners, right? So nothing was required to be done. Now, what is happening here is that they are saying in subsection 3, amended subsection 3, that it is not the survivorship, but by testamentary or intestate succession it will happen. Okay. So the coparcenary property shall not devolve amongst the only male member, but it will also now go to the daughter also, right? And the daughter is allotted the same share as is allotted to the son. So that automatic readjustment because of the survivorship will not take place under the amended act. Rather, it is the intestate succession according to which the shares will be allocated to the remaining members, in which the daughter will also be getting the same share because the daughter has become a coparcener now. So that's one of the consequences. This question is relevant. Why? Because they are saying in Vinita also there are various cases in which what has happened is that death has taken prior in time. The coparcener has died prior to 2005, right? And the proposition of law has been that if the co-partner died in 2004 or 2003, when this subsection was not there, okay, notional readjustment of share of the surviving co-partner already took place, right? And now the remaining co-partners had their shares available to them, which could not have been readjusted by virtue of this deeming provision of subsection 3. The court has negated it, saying that it's only the adjustment of the apportionment or share, it is not the finality. And the share of a co-partner in a coparcenary is always in flux. It always changes. If somebody adopts or a new coparcenary is born, it is always adjusted. So unless and until two things have happened, unless and until there is a disposition within the meaning of provision of subsection 1, or there is a partition within the meaning of subsection 5. Before that, the amendment can be made applicable. Right. So this is what the deeming fiction is here. It says not by survivorship, but by intestate or testamentary succession. Daughter will get as much as the son will get. It's automatically allotted to the daughter, right? By deeming fiction, it has already gone. The moment the coparcenary died, daughter also got it as much as the son got it. Then the share of predeceased son or predeceased daughter, as they would have had been alive at the time of partition, shall be allowed to surviving. Now, this is again the same thing that you read. This is again in order to cover the 4th degree, right? It goes and stops at 4th degree, because by the time 4th degree of coparcenary of daughter is also covered. So it's not only the benefit which is going to the daughter, the benefit is also by virtue of B and C is extended to the lineal descendant up to 4th degree, which is the rule of coparcenary, to relating to the daughter also. Now, for the purpose of this subsection, the interest of Hindu Mitakshara shall be deemed to be the share. Now, same thing which is there in existing. What is the meaning of the interest? And then the relevant is subsection 5, that nothing contained in this section shall apply to a partition which has been effected before the 20th day of December, but then the partition should be registered and or by virtue of the decree of a court. Now, since by virtue of subsection 3, by virtue of amended section 3, subsection 3, clause B and C, new beneficiaries have been added. Son of predeceased daughter, or son and son of predeceased daughter, etc., etc. Those beneficiaries have also been added in class 1. If we see amended section 7, which says in the Schedule of Principal Act, under the subheading class 1, these beneficiaries will be added. So this is the amended act. Now, in light of the conflict which happened between the two judgments, you can take up that, Vinita Sharma.
One more thing here. In the case of the Spanish, it talks about the partition effected by a decree of the court here.
In the case of
explanation 7, explanation 5.
Just 1 second. Explanation 5, yes.
5, but the subsection 5 expansion, where it says that partition means partition made by the execution of the deed of a partition duly registered under Registration Act, or a partition effected by a decree of a court here. So there is only two partitions which has been covered, which one partition, first partition, the partition by the instrument which has been registered
yes.
through Registration Act, and the second partition is partition through a decree of a court. Then not any other partition has.
So when you read decree of court, read final decree of court, not preliminary decree.
So what I'm trying to say, that any other partition has not been covered here.
That's right.
So, like you have mentioned that when the in the case of Sahu case, what you are trying to say here, although I have not gone into this part here, whether there was a consent decree, and based on the consent decree, some property has been disposed of by the by the member here, whether the female can claim that this has not.
No, hang on. You probably could not follow the development that I told you. What I told you there is that in Sahu there was a consent arrived at, consent decree filed, and one of the party of the consent was the daughter. Okay, based on that consent decree, a preliminary decree was drawn. Preliminary decree of partition was drawn. While this preliminary decree of partition was pending, to the best of my knowledge, which subject to correction, because I have also not gone through the entire judgment, I have read part of it. But then my understanding is that while the preliminary decree was pending, and after the compromise was arrived at in court, which became part of the decree, preliminary decree, the concerned coparcener there disposed of his share within the meaning of section 30 of the Hindu Succession Act to third person, which is being saved by virtue of provision to the subsection 1 of the Amended Act. Okay. Now, when all these things were pending, preliminary decree was still pending there, and final decree was yet to come, came this amendment before the final decree had come. Once the amendment came, the daughter filed an application before that court for recalling of that order of compromise and claimed her share as a coparcener, her share in the coparcenary property, that she is also entitled to the equal share. Because earlier she was not entitled to, she might have given a relinquishment deed or something, and the brother would have said that yes, I can sell it now. So the chronology of event is that there is a compromise is recorded in the court, based on which comes a preliminary decree of partition. Based on all these things, disposition takes place, and the matter in the court is still waiting for the final decree to come. Before the final decree could come, comes this amending act. On the strength of amending act, a lady goes, and before the final decree comes, she files an application for recalling of the previous order. Courts below, trial court had dismissed it, High Court allowed it, Supreme Court upheld it, saying that the final decree had not yet come. But then one of the argument of relating to the definition of decree under section 2C of CPC, read with section 97 of CPC, which says that if you do not challenge preliminary decree in appeal, you won't be able to challenge the final decree. Which means that as far as the preliminary decree is concerned, the rights of the parties are crystallized. Okay, so the partition which took place had been crystallized, and this argument has been taken there. But I don't know how it's been dealt with. I'll have to see that. So now you can resume because with Vinita Sharma.
I feel that you have already covered everything what we wanted to cover. Nothing is left more.
No, so Vinita basically has the difference of opinion of two judges, and how that has been dealt with.
You have already covered the Prakash versus Fulvati there.
Okay.
And what was the issue in Dhanamma? Because it was
Dhanamma said he'll apply retrospectively. There were 2-3 aspects, I think, which were being considered in Vinita. I think the basic conflict was between Prakash saying that this amendment is applicable only prospectively. So anything which has happened in past, you can't go back and claim it. Your entitlement comes only after 2005. Dhanamma said no. This is probably this is not the Prakash also said that the co-partner has died prior to 2005. If the co-partner is not alive, or if the daughter is not alive before 2005, then obviously this benefit cannot be availed. Benefit of amendment cannot come. Danama said it otherwise. It said that it can be applied even in a case where the partner has died prior in time, and it is not the death of co-partner which is relevant. Rather, it is the factum of birth of a daughter as a co-partner which is relevant, and therefore her birth gives her the right in her own to maintain a matter as a co-partner. Death will not be relevant. So there are some gray areas to be looked into, but so they have actually upheld Danamma and overruled Prakash in this larger bench, holding that the amendment is retroactive. I think the relevant part, the relevant conclusion I have with me, which I can read at para 129 of page 119, that says, the provisions contained in substituted section 6 of the Hindu Succession Act 1956 confer status of co-partner on the daughter born before or after amendment in the same manner as son with same rights and liabilities. Then the rights can be claimed by the daughter born earlier with effect from 9/9/2005, with saving of section 6(1) as the disposition or alienation, partition or testamentary disposition which had taken place before 20th day of December 2004. Since the right in Coparcenary is by birth, it is not necessary that father Coparcenary should be living as on 9/9/2005. So even if he is dead before that date, because the right is coming by birth, therefore it's not a relevant criteria. Then the statutory fiction.
It was the case in the Prakash, or it was the case
In Prakash, I'll take you to the relevant part. Just one second. Let's spend 5-10 minutes. Let's come to page 2, where the reference is being made. Page 2. Para 1. It says the matter has been referred to the larger bench in view of the conflicting verdicts rendered by two division bench in Prakash and Danamma. Now, what are the issues involved in the connected SLPs? Because this is an SLP which has been decided. If you look at the top, there are 7-8 SLPs.
Yes.
So right. So the SLP, which is what are the issues in Lokmani? High Court held that that section 6, as amended by Act of 2005, is deemed to be there since 17. So High Court in Lokmani had said that 6 is deemed to be there since 17/6/1956. That is when the Hindu Succession Act came into being. So that order of the High Court, and therefore the High Court had applied it retrospectively. Matter was challenged, and Lokmani was connected with this matter. Then second matter is Balachandra. Here again, retrospectivity of section 6 as substituted by 2005. The father, who was a co-partner in the joint Hindu family, was not alive when the act came into force. So here the father was not alive. Third SLP is the final decree had not been passed. Here the preliminary decree had come, final decree had not come. So they are saying that once preliminary decree of partition has come, it could not have been applied. The question which we discussed right now. Then fourth is whether section 6 is prospective, as the father died in 1994. Here again, 94 father is dead. Fifth is that the petitioner sought partition of his father's ancestral property. The suit was filed in 2001. Trial court granted 1/7 share to all the parties. The same was modified. It was held petitioner, the daughter were entitled to only 1/35 share in light of Prakash. So Prakash has been followed in Jaya Lakshmi, which is again challenged here and was tagged along. Then Indu Bai, and similar question in BK Venkatesh. Daughter have been accorded equal shares in item 1 of the scheduled property, which has been questioned. Now, what has happened in Prakash is coming at para 8. It was held that 6 is not retrospective in operation and it applies when both Coparcenary and his daughters were alive on the date of commencement of the Amendment Act on so and so. This court further opined that the provision contained in the explanation to section 6.5 provides for the requirement of partition for substituted section 6 is to be registered one or by decree. The explanation that we read can have no application to a statutory notional partition. Now, the statutory notional partition that we read previously, which is coming by virtue of survivorship the moment there is a death, right? So what the argument which is being taken here in Fulbati, or what Fulbati is holding actually, is that since prior in time, prior to this cutoff date, since upon death of the copartner, the property is already devolved upon the surviving copartner by virtue of survivorship, which is a statutory notional partition. You cannot apply section 6 and change the circumstance, right? The succession had already opened prior in time. The notional statutory partition is deemed to have taken place to ascertain the sphere of the deceased copartner, which is not covered either under the provision of section 6.1 or 6.5, including the explanation. It says that there is nothing in 6.1 or 6.5 which specifically provides for upturning the notional partition which had taken place by survivorship. There should be something which would have said that, notwithstanding what has happened there. So what Fulbati held, that since there is no such provision in the amended section 6, making the previous partition by legal fiction subject to the amendment, therefore it cannot be applied retrospectively in those cases where it has already been readjusted, shares have been readjusted by notional partition. The registration requirement is inapplicable to partition of property by operation of law, which has to be given full effect. So I think these findings were not very, these findings were quite sound finding given by the court in Prakash. But then what is probably weighing is the fact that the discrimination aspect and equality aspect, and that the fact that since you have become a copartner by virtue of birth, you should get the benefit by virtue of birth during your lifetime, even if the incident happens to be prior in time, subject to two limitations which are there in the amending act. One is that disposition under section 30, and two is the partition which is registered or the final decree of the court. Now, final decree or preliminary decree is something which is again here concerned, right? We are concerned. Now, what is Dhanama holding is in para 9. Section 6 confers full right upon the daughter copartner. Any copartner, including a daughter, can claim a partition in the coparcenary property. Now, the arguments are there. Submissions is made by union. I think what the main submissions are that it clearly says that the discrimination ground has been taken. If you see Article 15 ground has been taken here. It says it's a fundamental right. And it's not retrospective but retroactive. It enables the daughter to exercise their coparcenary right on the commencement of the Amendment Act, even though the right of coparcenary accrued for the daughter by birth of coparcenary. Coparcenary is a birthright. Then second says it's not disturbing something which has been crystallized. Third says unamended section 6, provided that male copartner had left behind a death. वो क्लास 1 में जो सेविंग था वो ग्राउंड ले रहे हैं that the daughter was entitled to limited share in the coparcenary interest of her father, not share as a copartner in her right. They were unable to inherit the ancestral property like son. The Mitakshara law not only contributed to discrimination on the ground of gender, was oppressive. These are the grounds. Then I think these are the grounds which are taken by the union. Devolution of personally. Then ground 7 is the decision of Prakash to the effect that there should be living daughter and living copartner. Now this finding that on the cutoff date, the daughter and copartner both should be living alive. This they are saying what union is saying, that this argument or this finding of Prakash is not considering the fact that the daughter has become a copartner by virtue of her birth and is a right she is having in her her own self, and it has nothing to do with the death of the copartner. The moment she is a copartner by birth, it doesn't matter when did the father die. The moment the father died, by virtue of Section 3, there is a deeming provision that on death of copartner. Does Section 3 say after this cutoff date? Let's see Section 3 for a moment. Amendment Act. Section 3 says, yes, it says after the commencement of this act, right? So it says after, where a Hindu dies after the commencement of this act, so deeming fiction is coming to play its role after the Hindu's death, after this cutoff date. But the argument which is taken in Vinita is that even before the cutoff date, if the Hindu is dead, then Section 3 deeming thing will come into picture, and it will because she is claiming it by virtue of her own individual right.
So the point
Not
is, Section 6.3 talks about that the death should be like there. Just hold on. Come to the Section 6 here. Section 3, where the deeming fiction has been applied here. Section 3 talks about where it dies after the commencement of the Hindu Succession Amendment Act. So it talks about that the death should be after the 9/9/2005, but the birth can take place any time before that part here. So when the birth has already taken place before that part here, the right has already accrued to her. Only part is that, as per the law, the right is being exercised as of now after the 2004, after 2005.
No, it says where the Hindu dies after the commencement of Hindu Succession Act 2005. What happens if the Hindu dies prior to the commencement? Because 3 is very clearly saying that 3 is bringing in intestate succession and flushing out survivorship. Okay, clear? As far as the Coparcenary property is concerned, subsection 3 is flushing out survivorship and bringing in intestate and testamentary succession. And it clearly says after this particular date. That means till this date, it seems that the legislature has saved the statutory, the fictional partition that had taken place based on survivorship, which was happening pursuant to existing section 6, right?
Yeah.
Now, if that is so, and if somebody who has died prior to the cutoff date, and by virtue of the existing section 6, the shares have devolved on the surviving co-partners, how can that be opened? I think one possible answer to this is that it is only the shares which have been allocated to them, which have been assigned to them. It is not since the share is in flux in a coparcenary, unless and until final partition takes place, share is not constant or permanent. There is nothing called permanence which is attached to the share of a coparcenary property. It is in flux, and every time there is a new copartner added, the share reduces. Correct. And therefore the court has said that section 6 survivorship is not a final call. The final call is partition or disposition. Until and unless by virtue of disposition or partition a particular share is finally affected, it makes no difference. It can still be done, and that is why 3 has been given an inroad, and Prakash has been overruled on that. Then,
due to the paucity of the time, because we are already at around 6 years, okay. Can we conclude, because as per the para 129 here?
Yeah, we can do that. We can do that. It's a lengthy judgment, actually. If you discuss the judgment, it'll take another an hour. Because if we go by each finding on each point, then there are at least 7-8 points which we'll have to deal with. It'll take time. So we can, for now, conclude. We can pick this judgment later on sometime.
So resultantly, the answer is like this one. The provision contained in Substituted Section 6 of the Hindu Succession Act 1956 conferred status of a co-person on a daughter born before or after the amendment in the same manner as a son with some rights, with the same rights and liabilities here. So it is the importance is the birth of the daughter, and birth can take place either prior to 2005 or after 2005. That is not an important part here. So yeah, even if the daughter has born before 2005, the benefit of the substitute section can be there. The right can be claimed by the daughter born earlier with effect from 9/9/2005. So if she has born earlier, then the right can be conferred or the right can be claimed by the daughter with effect from the 9/9/2005 with the saving as provided in the 6.1 as to the disposition or alienation, partition or testamentary disposition which has taken place before the 20th day of December 2004. Third, since the right in the co-parcenary is by birth, it is not necessary that the father co-parcener should be living as on 9/9/2005. This line is taking departure from the 6.3. Let's see that part here. The fourth, the statutory fiction of partition created by proviso of the Section 6 of the Hindu Succession Act 1956 as originally enacted did not bring about the actual partition or disruption of the co-parcenary. The fiction was only for the purpose of assignment shares of the deceased co-parson when he was survived by a female heir or the of class 1 as specified in the schedule of the Act 1956 or male relative of such female. The provision of the substituted section are required to be given full effect. Notwithstanding the preliminary decree has been passed, the daughter are to be given share in co-parcenary equal to that of the son in pending proceeding for the final decree or in appeal. In view of the rigid provisions of the explanation to Section 66, Subsection 5 of the Act of 1956, a plea of the oral partition cannot be accepted. So the oral partition cannot be accepted as the statutory recognized mode of partition effected by a deed of partition duly registered under the provision of the Registration Act 1908 or the effected by the decree of the court. However, in exceptional circumstances where the plea of the oral participation or oral partition is supported by public document and partition is finally evinced with the same manner as if it had effected by the decree of court, it may be accepted. A plea of partition based on oral evidence alone cannot be accepted and to be rejected outrightly. We understand that on this question, suits appeal are pending before the different high court and subordinate court. The matter have already been delayed due to the legal embargo caused by the conflicting decision that daughters cannot be deprived of the right of equality conferred upon them by Section 6. Hence, we request that the pending matters be decided as far as possible within 6 months. In view of the aforesaid decision, aforesaid discussion and answer, we overrule the views of the contrary expressed in Prakash versus Fulvati and Meghanmal and Magnamal versus TV Raju. The opinion expressed in Damanna is partly overruled.
Magnaman versus Raju has been a judgment which relied upon Fulvati. And a
Yes.
very interesting aspect is there.
Hmm.
The interesting aspect is that in Magnamal, a married daughter moved an app. Similar provision in the Tamil Nadu Act, similar amendment act came, right? In which, but then there was a specific provision whereby married daughter was denied this benefit.
Hmm.
A married daughter filed a petition as a co-partner to seek share in the property. Court held that though there is no such limitation in Section 6 of the Hindu Succession Act, and a married daughter is not denied here, and a married daughter can also maintain as a co-partner all the remedies that is available to unmarried daughter. There is a parity. But since Tamil Nadu Act clearly had a provision whereby this particular class was ousted from the benefit, and therefore that benefit cannot be given. So what Vinita Sharma is saying, that relied upon judgment was decided on its point of its own. It had no occasion at all to rely on Phulvati, right? So Prakash Phulvati, because Prakash Phulvati, that on the cutoff date, Coparcenary and daughter both should be alive, was not a question involved in that judgment which relied upon that. That's what. So is he also overruling it?
Yes.
The other judgment also. Yes.
The court is also overruling the Magnamal also.
Yes.
The
Because it is holding that the father and daughter both should be alive.
Yeah. The opinion expressed in Damanna is partly overruled to the extent it is contrary to the decision. Let the matter be placed with the appropriate bench here.
Damanna is also overruled?
To the extent which is contrary here.
To this. Okay. To larger bench. All right.
So, thank you, Ajay. Thank you for the very nice discussion on the Hindu Succession Act. And whoever has participated, we have learned a lot here. And Naman?
Yes,
I
sir.
think Naman and
Yes, I'm
Karthik
here.
both should work on crystallizing the things that we have discussed, and also if they can take into account the subsequent decision of Sahu and read that, and the point which they should look into Sahu is as to if there is a disposition already made within the meaning of Section 30 of Hindu Succession Act, under what circumstances, try and focus to that because that's the relevant point. Under what circumstances that has been ignored, and the daughter has been given a 1/3 share in the property.
Yes.
So that will cover the disposition part, because disposition is saved by virtue of the proviso to subsection 1. Okay, so if that is saved and if the disposition is validly done, why that has been set aside or ignored? Okay.
Yes.
So make your article or compilation in this and share with us. I think the points that we discussed are very clear. In case there is any doubt or anything you want to discuss during the course when you prepare your article, when you articleize it, you might come across some doubt or something, or the direction in which it is to be done. Then for that you can always give me a call, but try and do that by tomorrow afternoon latest, so that by tomorrow evening, because the more delay would result into more disappearance of the thought.
Okay.
Right. Very well. Thanks so much.
Thank you.
Up.